if we don't like the result, let's amend the Constitution. I'll end by saying that it seems that there's not going to be opposition to Hillary Clinton on this, or Ken Salazar, which reinforces the point that the Constitution seems to be able to be impugned or ignored with impunity when it's unlikely that a violation is going to be seen as justiciable, or when it seems to be a more political question or some obscure part of the Constitution rather than a real part of the Constitution. I'm not sure what standard that is. It must be in some other footnote of Caroline Products, maybe, that devises the different types of constitutional rights that we have, or powers or limits on government. But we see these types of obscure provisions of the Constitution coming up to bite us again and again. It's not just this nomination during a change of administration. The Patent and Trademark Office, there's a case that's going up before the Supreme Court. Certain appointees to the Patent and Trademark Office weren't appointed correctly under the proper authority of the Department of Commerce, and we have a serious issue with hundreds, literally, of decisions by these patent judges which are being appealed under the justification that that patent judge didn't have duly constituted authority to make those rulings, and so Congress has rushed through a bill to give them retroactive authority. Well, we don't tend to like retroactive authority in constitutional government, so that's a case, that's a joint case that's winding its way through the courts. The PCAOB, the Public Companies Accounting Oversight Board, PCAOB, there's a case that was recently denied en banc review 5-4 by the D.C. Circuit in a challenge to the PCAOB is the body that enforces Sarbanes-Oxley, among other things, and an investment company and a public interest law firm have sued the PCAOB because members of that commission are appointed by the SEC, not by the president, not by the chairman of the SEC, who's appointed by the president, but by the whole SEC as a body. And that body, of course, is not appointed by the president, in clear violation of the Appointments Clause of the Constitution. That's another case that there's going to be a cert petition, and Cato is going to be filing an amicus brief on. And closest in our news and in our minds, the TARP, the bailout. Clearly facially unconstitutional under both the non-delegation doctrine, because there's no intelligible principle which Henry Paulson and the TARP committee are supposed to go about their duties. And we can see this now that the auto industry apparently is going to get some TARP money, and who knows what it's going to be used for. And also it's a violation of the Interstate Commerce Clause, and there's simply no power for Congress to buy distressed assets, it seems to me. So, I mean, whether the Constitution is not a suicide pact, was the bailout, or if it had been constituted differently, a different bailout necessary to preserve the republic or whatever, that's different. That's a prudential, policy argument. And again, I'm not a financial expert. I'm even less of a financial expert than I am a foreign affairs expert. So I certainly am not going to talk about the policy wisdom of the bailout, but as a constitutional matter, it should have been addressed. The argument should have been made, yes, there are problems, but this is so important, etc. I'll leave you with another quote from Professor Paulson's excellent and short article, Is Lloyd Benson Unconstitutional? Oh, and before I read this quote, I'll mention that Professor Paulson had a sequel, and on the point of whether COLAs are really pay increases or not, how the Constitution treats inflation, he wrote a sequel called Is Bill Clinton Unconstitutional? Because if we have kind of an act of liberty or a living Constitution view, well then, the 35-year-old, the mature 33-year-old, or even a 35-year-old, which it says in the Constitution is the requirement to be president, well, shouldn't we take into account that at the time of the founding, life expectancy was, 50 or 55, and the maturity intended of Thomas Jefferson was 32 when he wrote the Declaration of Independence. Perhaps the founders had a different conception of these things, and by the time Bill Clinton took office, of course he was 46, I believe, when he was elected. The limit was about 58 or 60. So in fact, Al Gore would have been too young. Newt Gingrich, Speaker of the House, would have been too young. Clearly, Strom Thurmond was the lawful president in 1994 when Michael Paulson wrote this article. Anyway, here's what Paulson said in the Lloyd Benson article. There's a terrible tendency on the part of lawyers, including executive branch lawyers, to equate the absence of standing to challenge some government action with lawful authority to engage in such action. This tendency is bred from the bad habit inculcated in law school and reinforced by judges of thinking of law solely as the product of court decisions rather than as an objective body of commands and prohibitions. Where there is and can be no decisional law, there is thought to be no law. Such an approach is as wrong can be. A constitutional violation is no less a constitutional violation simply because of the absence of a judicial ruling to that effect. The President takes an oath to uphold the Constitution. That duty exists whether the courts are able to act on a matter or not. The Constitution is binding law for the executive branch as well as for the courts. Even if one holds a Holmesian conception of law as nothing more than a prediction of what the courts will hold, one is still a Holmesian bad man in refusing to adhere to what courts would and should hold if an issue could properly be made the subject of a lawsuit. When elected officials regard the Constitution as not violated in fact simply because of the absence of any litigation risk, they flout their oaths to uphold the Constitution. It is no different from a lawyer who advises a client that he has the legal right to commit a crime because there is little likelihood of his being caught and punished.
Thank you, Ilya. Very good. Appreciate it. And John as well. This discussion only adds to my outrage over the way we've been treated for raising this issue because, the Clinton attack machine comes out as soon as we make a noise about this, and everyone poo-poos the concerns about this. But this is a substantive concern. And as a non-lawyer, having read the histories here through the law reviews and listening to the comments here, it seems to me this clause is as relevant as ever. And the Founding Fathers would be offended by this current situation, that this office, the Secretary of State, is being used in an arguably improper way, according to the intent of the clause, and it's obvious, the language beside the point, but even going to the intent, to take care of a political problem for Barack Obama in the U.S. Senate. And that the clause was designed to prevent the offices of the executive branch from being used in that way. And there's no doubt that not only is the letter of the law not being followed, but the spirit of the law, and it's as relevant in this situation as it would have been George Washington considering some of his first Supreme Court appointments. Do you have an objection to that analysis or clarification? Or
no. The purpose was to create disincentives on the front end when offices are created or their salaries are increased. And I think that at least the portion of the framers who were pushing the Emoluments Clause would likely have been hysterical about the idea of regularized increases in executive salaries because they were very, very concerned about the tyrannical nature of centralized power in a national government. So they would have viewed the Emoluments Clause as being a very effective brake on the tendency of Congress to create regular increases in salaries for federal offices. So I do think that the clause was directed at discouraging that sort of conduct, and the outgrowth of that conduct is that senators and congressmen become temporarily ineligible for offices whenever the salary bumps up pursuant to this scheme for increasing executive salaries.